So turning now to what it actually means for firms who are in the TPR or in the SRO, because as I mentioned, for firms in the CRO, there won't be much change after the end of the transitional period. The deemed Part 4A permission for firms in both of these categories means that they will continue to be an authorised person for the purposes of UK law, and therefore that they'll be subject to the supervision of the UK regulator. And as I mentioned, the deemed permission will cover the activities that the firm was permitted to carry out in the UK via passporting immediately before the end of the transition period. And so all of these firms will be subject to the same obligations and supervisory framework as if they were a UK Part 4 authorised firm. So that means firms in the SRO or the TPR with an establishment in the UK will be required to comply with the same rules that apply to other third country branches. But for firms in the SRO or TPR without a branch, so people who are purely cross-border service providers, a more limited set of rules will apply. And these include the rules that would apply to a PRA authorised firm without a UK branch, so including the fundamental rules, those relating to auditors, change in control, and similar, and the use of skilled persons, so that's the FCA and the PRA's powers of supervision. It also means that the senior managers and certification requirements that apply to third country branches will apply, although in a slightly more limited basis than applies to UK firms, and certain financial services compensation scheme rules will also apply. Just focusing briefly purely on firms who are in the SRO, I wanted to flag that all firms in the SRO are required to provide a run-off plan describing their plans to run off their business before the mechanism expires. And those firms are going to have to provide an annual update on their progress to the regulators and advise of any unexpected divergence from the plan. Actually, touching briefly on the SMCR requirements, and I'll do this for insurers specifically because I'm afraid there's still less clarity about the rules that are going to be applied to intermediaries. The PRA is, as I mentioned earlier, the PRA has decided to apply a streamlined version of the senior managers rules. And so the compliance with the SMCR is not a precondition of entry into the TPR, but insurers in the SRO and the TPR will be required to have at least one individual approved to perform the head of overseas branch or SMF 19 function. And so both firms in the TPR and the SRO, however they entered the SRO, will need to complete and submit a TPR SMF application form, which will contain key information about the individual that they propose to perform that SMF function while they remain in the SRO and or the TPR. The firm will also need to complete and submit the related statement of responsibilities form, which you may not have had to do at this stage. And after receiving that application, the PRA, with the FCA's consent, can decide to treat the individual that you have nominated as your SMF 19 as approved. That means that these individuals are not going to be required to undergo the standard PRA fitness and proprietary assessment to be eligible for deemed approval. But the deemed approval only lasts for 12 months. So importantly, the relevant individual will need to undergo a full fit and proper assessment and obtain full PRA approval as an SMF within 12 months of the firm's date of entry into the SRO or the TPR. It's probably also worth saying that for SRO firms, the fit and proper assessment and the responsibilities of SMFs will be tailored to reflect the narrower obligations of runoff, and in particular, the prescribed responsibilities that apply to SMFs in business as usual firms will be disapplied. But the SMFs in this firm will be responsible for ensuring the orderly runoff of the firm's UK regulated activities. And similarly, the PRA is not applying all of their prescribed responsibilities for third country branches to firms who are in the TPR. Instead, the only two that will apply is the existing prescribed responsibility for compliance with the UK regulatory system, and a bespoke new prescribed responsibility for managing the process of obtaining their UK permission. So the SM and CR is not the only place that the PRA has made concessions to EEA firms who are now coming into the UK. It's recognised that firms entering the SR and the TPR may find it challenging to comply immediately after the end of the transition period with some of the requirements in our rules that will apply to them for the first time. So as a consequence, although this list is subject to any updates that may come out of the temporary transitional powers that the regulators have, the PRA will grant firms transitional relief in relation to certain aspects of the third country requirements. But as you can see from the slide, these are mainly in relation to reporting and capital requirements. Looping back briefly to the UK regulatory requirements that will apply to all EEA firms, I wanted to discuss the application of the Financial Services Compensation Scheme rules. These are complicated, but I've tried to summarize them on this slide. So in short, for insurance policies that are issued before the end of the transitional period, the existing FSCS protection for insurance policies which are issued prior to the end of the transitional period will be maintained for as long as the insurer remains a relevant person under FSMA. And who is a relevant person? Well, it includes any person that was an authorized person at the time of the act or omission that gave rise to the claim. And that captures both EEA firms in the SRO and the CRO, as they are authorized persons for this limited purpose, and firms who are in the TPR. And both categories of firms are therefore required to pay the FSCS levies. For insurance policies issued after the end of the transitional period, or for policies which are reissued in that period, if they're issued through a UK establishment of a TPR firm, the policies must relate to a risk or commitment situated in the UK, the Channel Islands, the Isle of Man, or Gibraltar in order to be protected. New policies relating to EEA risks are not going to be protected. For policies that are issued or reissued after the end of the transitional period, which are issued through an EEA establishment of a TPR firm, only the UK risks would be FSCS protected. So new policies relating to EEA, Channel Islands, Isle of Man, or Gibraltar risks are not. And policies issued through an EEA establishment are only eligible for FSCS protection where the firm does not yet have a UK establishment. So, for example, this captures TPR insurers who are still in the process of setting up a UK establishment, who issues policies through their EEA establishment after the end of the transitional period. So in short, that means that if a TPR insurer already has an establishment in the UK when it is in the TPR, so for example, it enters the TPR in respect of both freedom of services and on a freedom of establishment basis, the FSCS protection would be available for policies that the TPR insurer issues after the end of the transitional period from the UK establishment. But any policies that the TPR insurer issues through their EEA establishment after the end of the transition period would not be eligible for protection. As I said, it gets quite complicated quite quickly. As a reminder, the FSCR provides limited permissions for firms to perform existing contracts, and so it doesn't allow firms to carry out regulated activities in relation to new contracts of insurance, except where this is necessary to service pre-existing contracts. So if policies are issued by SRO insurers with a UK establishment, the FSCS protection would apply, as it does for policyholders of insurers in the TPR, which means that policies in respect of risks situated in the UK, Channel Islands, Isle of Man, or Gibraltar would be eligible for protection. But if they are issued by an SRO or a CRO insurer without a UK establishment, then the protection would only be available in respect of risks situated within the UK. It's probably worth flagging here that there are a number of reasons why insurers could cease to be a relevant person, and that if a firm is no longer a relevant person at the time the act or omission that gave rise to the claim occurs, or the policies have not been transferred to a relevant person, because that is an option, the FSCS protection would not be available. But existing FSCS protection would continue to be available for claims in relation to the acts or omissions that arose before the loss of the relevant person status.